everybody. Here we are at the Freedom Hub Working Group, and this week we've got a really nice special guest in store, as you'll find out here momentarily. We do want you to appreciate we do these every week, and then we also post these for those that can't necessarily make them here. And you'll notice we've created a simplistic bit.ly. It is case sensitive, so you will want to make sure if you try to use it that you type it in the same way. And just to quickly show you, this is where it'll take you. And we actually post on BitChute, and we have some stuff coming up on YouTube. But we like to support Brighteon because this is the free market competitor to YouTube. And these are all the people that got banned off of YouTube or Facebook, and they gravitated to this platform. And so we've got a wealth of interviews and programs we've done, and it goes back multiple pages. So you'll see there's a wealth of stuff here. And there's not a bad one in the bunch. So you'll certainly want to come here and take a peek. And then, as it also indicated, we're sponsored by your Freedom Hub, which is the host behind all of this. And this is where a lot of cutting and kind of disruptive things are being uncovered. And this is just one of them here as a replacement to the idea of using insurance for your health. So thanks again for coming today. Let's kind of start to jump into who we're working with today. So Charles, if I can get you to.
Sure. Jeff, thanks so much, and welcome, Lee. Today we do have a big wig in the movement, Lee McGrath. He is the Senior Legislative Counsel for the Institute for Justice, and he is the managing attorney for its Minnesota chapter. I worked with him a bit, as well as some other guests on this webinar during the Our America Initiative days on asset forfeiture and licensing reform. And those are two of his bigger issues. He also is a former international banker at the First National Bank of Chicago. So he has that combination of high finance knowledge and prowess, as well as lawyering. And that's what IJ is known for, is suing their way to liberty, mostly for economic liberty, for truckers or more taxi options or licensing option. And today he's going to talk about some of their broadening from just suing to lobbying, and do a little bit of focusing in the over-criminalization area, specifically with asset forfeiture. So that is today's guest. Jeff?
Fantastic. All right. I am going to officially quit my sharing of the screen. And Lee, if you wanted to go ahead and just relaunch your screen again.
Well, wonderful. Thank you so much. Jeff, Charles, thank you for the forum and the kind words. The Institute for Justice is best known for its litigation efforts, and most famously for litigating against the government taking your property. The Kelo versus New London eminent domain case is a case that we actually lost at the United States Supreme Court, but to a large extent put IJ on the map. And so property rights are a core component of IJ's litigation. And last year, we were fortunate to win at the United States Supreme Court in a case involving forfeiture, and whether the Eighth Amendment's protection against excessive fines applies to civil forfeiture in the state of Indiana and in other states. And in the case of Timms versus Indiana, the Supreme Court decided unanimously in our client's favor, Tyson Timms's favor, and said the government can't impose an excessive fine. Those sorts of cases, the eminent domain case, where we lost, and the forfeiture cases and other cases in which we won, lend themselves to other activities, including knocking on the door of state legislators and asking them to do less or to reform processes or to repeal bad laws. So what I'd like to do today is walk you through a discussion piece and leave plenty of time for your questions about what's going on in the area of forfeiture and IJ's work to end civil forfeiture and replace it with criminal forfeiture. So let's dive into this. And what I'll do today is walk through some of the areas in which there is agreement between people across the political spectrum and between advocates for reform, prosecutors, members of law enforcement. Then I'll jump into some definitions. So we have the foundation to talk about about seizures and forfeitures. I'll spend a little time talking about the difference between civil and criminal forfeiture. and then point out once again that IJ's legislative strategy, as well as litigation strategy, we dream of the day of a colleague of mine standing before the United States Supreme Court and making the case that civil forfeiture is an insufficient process. And what the process that all Americans is due is the criminal forfeiture process. Give some historical background and point out when civil forfeiture does make sense. And it's through this understanding of when it does make sense, you'll see that there are many areas where it's used today across the country where it doesn't make sense. I'll invite you to think like an accountant and then talk about some legislation that includes a reporting model, some of the features in our criminal forfeiture model, and let's engage in a discussion at about 4:45 or so. All right, so here's one thing I think all Americans agree on. Crime shouldn't pay. And no one has a property right or a constitutional right or any right to the fruit of crime. So from that perspective, it's completely legitimate for the government to confiscate the fruit of crime. And we could have a good discussion, a good debate as to whether it's equally legitimate for the government to confiscate the instruments of crime. But part of advocating for proper rights is ensuring that the government protects those rights against others. And so there is a legitimate function of confiscation of the fruit of crime. So we do not oppose forfeiture. The debate is what type of forfeiture, or how does that forfeiture take place? Does it take place in a civil context, or does it take place in a criminal context? For us, my colleagues and me, our goal is to end this civil forfeiture and replace it with criminal forfeiture. States like Nebraska, New Mexico have done that. North Carolina long has had that. And I'll dive into this difference between civil and criminal forfeitures in just a few minutes. But let's go to some definitions, understanding the difference between seizures and forfeitures. And the best way to think about this is the roles and who is doing what. Police, highway patrolmen, sheriffs, they do seizures. And the seizures are the taking of property, taking of possession of property. And that occurs on the highways, the byways, the streets, homes, and other places. And in order for police to do that, they have a relatively low standard of proof of probable cause, that they believe that the gun, the cash, the car are associated with a crime. Forfeiture, on the other hand, is very different. Forfeiture is the work of prosecutors. So first the seizure takes place by the police, and then the question becomes, does the forfeiture take place? The different function of taking title to properties. So forfeiture occurs in courtrooms, and it occurs in the offices of prosecutors as part of plea agreements. And so the standard of proof is higher. So in some states, the burden is on the prosecutor to prove by 51% or preponderance evidence that the car was an instrument or the cash was the proceeds. In other states, clear and convincing evidence, one thinks of that about being approximately 70%. And so cops are in the seizure business, prosecutors are in the forfeiture business. One deals with taking possession, the other deals with taking title. So here's one way to think about it. I've told this to numerous reporters when they're writing. Never say this sentence: my bill, or the bill that my organization is supporting, requires a person to be convicted before police can seize his property. If you think about it in relation to our last slide, it's a pretty obviously silly observation, but it is commonly made. In order for this to happen, you'd have to impanel a jury on the side of a highway, have a trial on the side of a highway before the police can take possession of property. Well, that just doesn't make sense. But what you can say is that my bill, or the bill that my organization is supporting, requires that a person be arrested, charged, and convicted as a prerequisite before the prosecutor litigates the transfer of title in the same criminal court. So said differently, a lot of the forfeiture reform that the Institute for Justice and organizations like the Platt Institute and other organizations across the Americans for Prosperity, in the ACLU, are involved in really focus on this component of forfeiture, the work of prosecutors. What has to happen before the title is transferred, and where does that litigation associated with transferring title takes place? So I'm going to spend most of today's discussion on talking about work of prosecutors involved in the forfeiture process. So that's big definition one. Here's definition two. This difference between civil forfeiture and criminal forfeiture. Civil forfeiture is a bifurcation. It's a division. The person who is arrested on the side of the highway by a police officer is sent off to the criminal justice system. But his car and his cash are sent off to the civil system. And in my eyes and the eyes of my colleagues, we view this as sort of an unnecessary and unnatural separation. The incident, whether it's the possession of drugs, whether it is the engaging in prostitution, whether it is driving under the influence, there's a single incident. But in civil forfeiture, a separation occurs, and a natural separation occurs. The person is sent off to a jurisdiction where he's considered in personam. By contrast, his property is sent off to a civil jurisdiction where it's in rem jurisdiction, the legal fiction that law enforcement, that prosecutors can litigate against property. By contrast, in Nebraska and New Mexico and North Carolina, there's one system. There's none of this unnatural separation. The person driving through Lincoln or through Albuquerque or through Charlotte gets stopped, gets arrested. That person goes into the criminal justice system, and his car, his cash, his guns go into the same criminal justice system. And he must first be convicted in that system as a prerequisite to the litigation associated with transferring title. And that litigation occurs in the same courtroom, in front of the same jury, in front of the same judge, with the same public defender as the prosecution of the suspect. We're big fans of in this world, criminal forfeiture is far better than the unnatural process of civil forfeiture. All right. So let's tie this in a bow and see where civil forfeiture, put a bow on this and see where civil forfeiture does make sense. And it does make sense when the suspect is beyond the government's personal jurisdiction. So in other words, it does make sense in admiralty law. The shipper may be in Barcelona or London or Dublin or Buenos Aires. That shipper who might be violating admiralty law, might be violating tariff laws, might not be flying under the right flag. He is beyond the jurisdiction. Therefore, the legal fiction of litigating civilly against his ship, against his cargo, makes sense, because law enforcement, police, sheriffs, prosecutors cannot get their hands on that shipper. By contrast, it doesn't make sense in issues involving controlled substances, DWI, or prostitution, because their law enforcement almost inevitably, almost all the time, can gain personal jurisdiction over the defendant. How did this come about? So here, once again, it comes about from admiralty law, that the king was forced to prosecute against the ships and the cargo because he couldn't gain jurisdiction. The owner was beyond in personam jurisdiction. And so the legal fiction of in rem jurisdiction was adopted. And it responds to the practical necessities that we just talked about for the enforcement of piracy laws, custom laws, admiralty laws. In the United States, in 1789, most of the tax revenue in the United States in the 18th century was collected through tariffs, and civil forfeiture made sense there because the taxpayer was beyond the personal jurisdiction of the federal government. It was used in Prohibition, but it came back in 1978 as part of the Drug Control Act. And in 1978, that Drug Control Act of 1970 was amended to include a civil, and this is the great flaw. For many reasons, this is the flaw that introduced the idea of civil forfeiture of all money, negotiable instruments, securities, or other things of value furnished or intended to be furnished by any person in exchange for a controlled substance in violation of this subchapter. Then in 1984, the real kick came in. In 1984, Congress changed the law to allow the proceeds from civil forfeiture to go to the Justice Department and the Treasury Department. And this created the incentive for law enforcement that all forfeiture-related expenses and various law enforcement purposes could be paid for by the acts and the acts alone of law enforcement deciding what type of crimes to raise in terms of priority and what type of efforts to go to engage in. So that's the background. And the key to the background is understanding that there were lots of decisions that were made. Principally, the one that is most historically problematic is the use of civil as opposed to criminal forfeiture. And then secondly, violating the separation of powers and allowing law enforcement, part of the executive branch, to raise and appropriate to itself its own funding. Now let me shake it up a little bit with you and invite you not to think so much about due process or issues of standards of proof and burdens of proof, but to invite you to think like an accountant for a few minutes as we begin to focus in on the type of reforms that IJ and AFP and the ACLU and state-based think tanks are engaged in. So it's quite contrary to one's intuition, but the biggest priority issue, these are all important, but the biggest thing for legislators to understand, for advocates to understand, are not issues of process, not issues of the lack of a conviction prerequisite, not the standard of proof or the burden of proof or how the proceeds issue. The most important thing to conceptualize here is size. How big are these seizures? And what are the implications as they relate to the other factors? And so I invite you to stick with me here as we talk about the size of seizures and how it impacts these other important issues of process, conviction prerequisites, standards and burdens and proceeds. Law enforcement likes to show photographs at state legislators, and there inevitably are pictures of large amounts of money, notorious characters, and bricks of drugs. This is the image that law enforcement's narrative takes place. But the reality is much different. The reality is that the type of seizures that police and sheriffs and highway patrolmen on average are taking in do not fill the narrative, do not meet the narrative, are inconsistent with the narrative of hundreds of thousands of dollars wrapped in plastic, stuffed in the panels of 18 wheelers. In fact, in states where we have data, what we have found is that it's very, very different. So Minnesota is one of those states that has been reporting for over 20 years. And what we know about Minnesota, the forfeitures, is there are a lot of them. There are approximately 8,000 of them a year. And quite contrary to the narrative of hundreds of thousands of dollars, the average forfeiture in Minnesota is $1,459. In fact, you can see at the bottom here, only 1% are greater than $10,000. 99% are of these cases are less than 10,000. And let me focus you in on this middle number, the $5,000, because I'm going to use that as a proxy, $5,000, as what it costs to hire an attorney in Minnesota to litigate a forfeiture case. 94% of the cases in Minnesota are less than $5,000. So what happens? You're driving on the streets on the highways of Minnesota, St. Paul, Minneapolis, Rochester, and you get stopped. You get arrested, your person goes into the criminal justice system, your car, your cash go into the civil system. In Minnesota, what the law requires is that you file a lawsuit against your property. So McGrath versus 2008 Chevrolet Impala. In other states, McGrath would have to answer a lawsuit filed by the prosecutor, but it takes the property owner to do something. It requires him to engage in the litigation process. In Minnesota, we know that 95% of property owners don't engage. They don't file that initial lawsuit of McGrath versus 2008 Chevrolet Impala. They don't do it for many reasons. And one of the reasons is that the average forfeiture is only $1,459. And they only have 60 days to file it. So in other words, it doesn't make sense for a property owner in Minnesota to pay an attorney $5,000 to represent him and file a civil lawsuit against his own property when the average forfeiture is less than $2,000. So in 95% of the cases, the property owner rationally walks away for this and other reasons, and title is transferred. The work of the prosecutor is easily accomplished in his office through an administrative process. So here's my invitation to you. Think like an accountant. When thinking about reforms, yes, those other factors are important, but the key dynamic is to understand and get the data so that you can see that you're not going to change anything unless you address the problem of economics, unless you address the problem of that an accountant would begin to think about. Why pay $5,000 to try to get back something that is far less than $5,000? even if you've done nothing wrong. So let me now turn to a couple of things that we're looking at in the model legislation. And all of this is on IJ's website, ij.org/legislation. Principally, what we're trying to do is overcome this narrative. And secondly, one of the hardest things I have to say to well-intentioned and very principled state legislators is don't go for the immediate fix. Let me dive into both of those issues with you. In New Mexico, in 2015, some incredible things occurred, and we had a perfect storm in which we were able to do everything in about 96 hours. The ACLU, the Rio Grande group, and others in Santa Fe were just extraordinary, and a massive, in fact, the platinum standard was enacted. One of the reasons that happened is that it was first, and law enforcement was not prepared for this incredible effort that came about because of a scandal. I don't think the dynamics will ever repeat themselves in New Mexico. And so the first step that I advocate with groups and state legislators is getting a reporting bill enacted, because data is needed to overcome the narrative that law enforcement is very effective at making. One way to think about law enforcement's effectiveness is to think about who sits on the committees, the Public Safety Committee, the Judiciary Committee. They tend to be former prosecutors, former judges, former retired police officers. And so those people at the state legislature serving on the relevant committee tend to defer when there are issues of uncertainty to law enforcement. And so reporting is a big deal. Reporting is essential to point out exactly how law enforcement uses seizures and prosecutors do forfeitures. So 22 states have enacted reporting. The really good ones include Arizona, Colorado, Kansas, and New Mexico. Let's assume we have the data. Let's assume we can talk to legislators with the precision that comes from the type of data we discussed in Minnesota. There are a couple, we have a complete criminal forfeiture model. It ends civil forfeiture, it replaces with criminal forfeiture. It's about 12 pages long. It is based on what New Mexico did. It's been refined over time. There are currently bills in South Carolina and in Minnesota that address that are based upon this criminal forfeiture model. But there are certain components of it that I think might be constructive to highlight. One is just stopping certain property from even entering the system. Prohibit police officers and sheriffs from seizing real property of a person's residence, currency of a nominal amount, $250, $500, $750, and cars of $2,500. This speaks to the economics. This speaks to this feature, this component speaks to the problem that it's irrational for property owners to hire an attorney for $5,000 to try to get back $500. It also speaks to the economics of prosecutors. They shouldn't be using their resources to try to forfeit $500 or an old car worth less than $2,500. And certainly these small seizures, it can be argued, are not a real deterrent to the type of crime that is spoken of that's used to defend forfeiture. Another feature is dealing with a problem that's associated with the fact that there are two sets of laws. There's state laws and there's federal law. And any advocate for reform of state laws has to be cognizant of the fact that law enforcement can circumvent those reforms by outsourcing the forfeiture litigation to U.S. attorneys under federal law under the program called equitable sharing. So let me talk about Missouri as an example, the extreme example of how a relatively good state law has been ignored. Quite simply, a few years ago, Missouri passed a law that put all the forfeiture proceeds into the education fund. What that did was it made the federal program under equitable sharing very attractive to law enforcement. On average, over the last couple of years, the state forfeiture law has produced forfeiture proceeds of only about $110,000 a year. By contrast, the federal forfeiture, the outsourcing program to federal attorneys under federal law, under equitable sharing, has produced forfeiture proceeds sent back to Missouri in the range of $9 million. So 110,000 versus 9 million. So that beautiful law that the legislators in Jefferson City spent weeks debating and negotiating and getting enacted has been circumvented by federal law. So there are means that 7 jurisdictions have enacted that are concisely written into our model legislation that limit or prohibit adoptions and limit joint task forces. At the core of this issue is the proceeds. A third type of reform, substantive reform, is redirecting the proceeds and divorcing the funding from police and prosecutors' action. Put the money in the general fund. Put the proceeds in K-12 education or scholarships, or even put them in a general grant program. But at the core, this law in many states is has incentives that drive behavior that is focused on proceeds. Let me talk now about one of the mistakes that I made and invite you to avoid it. As we discussed, one of the big types of reforms that goes on, lots of reforms go on, don't take into consideration the problem of size. And they tend to want to tweak things like standards of proof, whether it's preponderance or beyond clear and convincing, or they tend to shift burdens. Those types of tweakings are flawed. Those types of tweaks are flawed because they don't consider the high cost of even entering the system, even beginning the litigation, even getting to the point where you're thinking about standards of proof and burdens of proof and things like that. The property owner just isn't going to file the lawsuit or answer the lawsuit. One of the things that we've come to learn, particularly from my own experience of doing this in Minnesota, is the ineffectiveness of putting a criminal conviction in front of the existing civil forfeiture. So let me put that a little bit more in context and flesh that out for you. You've heard me in this presentation of saying that one of IJ's goal is to end civil forfeiture and replace it with criminal forfeiture. We like the idea that the prosecutor has to gain a conviction, but we want that to take place in criminal court. And we want the forfeiture to take place in the same court. one sort of hybrid that has come about, in fact, came about in Minnesota that I was involved in, was to just stick the criminal conviction in front of the existing civil forfeiture process. This has not been effective. This has not changed anything in Minnesota, and it hasn't changed anything in Minnesota because of the economics of not filing that lawsuit within 60 days. So here are the numbers in Minnesota, and this is a busy page, but let me just walk you through those. Since Minnesota enacted that law that I advocated for, the number of forfeitures in 2014 were 6,874. They went down in 2015, and then they've gone up in 2016 and 2017 as well. So that criminal conviction requirement in front of the civil forfeiture hasn't reduced the number of forfeitures. It also hasn't changed the dollar amounts. Before going into effect, the law going into effect, about $9.5 million were seized. Went down a little bit in 2015, came back in 2016, 2017, down a little bit. And the average forfeiture has stayed roughly the same. You would think that if a criminal conviction were meaningful, that there would be higher average forfeitures, but they've been relatively the same. So in other words, the celebration of passing that law in 2014, thinking that we were achieving something, has not proven out. We really didn't change anything in Minnesota by sticking a criminal conviction in front of the state's existing civil forfeiture process. So where we are in Minnesota today is that we have a coalition of advocates that includes the ACLU, includes AFP and some other groups, and we are supporting efforts to end civil forfeiture and replace it with criminal forfeiture. Let me stop there and invite your questions, your comments, your criticism, and also thank you. So.
Very good, Lee. That was really fantastic. I'm going to kind of kick it off here. First off with a definition, and then at the same time, a kind of a bit of a question here. On the definition, when you were talking earlier about it being in that personal jurisdiction, when it's outside that, what's kind of the layman's definition of what is personal jurisdiction? And then, why in this instance did you guys decide that this, of all of the different things you've got your finger in, that this was such an important one to become, a big focal point?
Very good. Thank you. So the idea of personal jurisdiction is that you, a human being, you, a person, are in the court system. That the court has has control over your freedom. By contrast, in rem jurisdiction, the thing that's in the court is the thing. In rem means against the thing. And so what the court is considering, what the prosecutors are litigating is the title to that thing. And separating them, once again, doesn't make sense because both the alleged guilt of the alleged crime against the person and the involvement of the cash or the car arise out of the same incident. At the Institute for Justice, we saw this issue very much similar to the issue of eminent domain. It is a legitimate function of government to take property. In eminent domain, it's legitimate when there's for a public use and there's just compensation. In forfeiture, it's legitimate when it is the fruit or the instrument of a crime for which a person has been convicted. But like so many things, it is not, it is the abuses at the edges, the excessiveness of the expansion of a legitimate government function into an illegitimate or an excessive one. And so this was a natural outflow at IJ from the work that my colleagues did representing Suzette Kilo and other property owners who faced their stuff, their homes, being taken.
Yes, it's interesting. I love the little institutional ads that you run, and there's one that's on the back cover of A Coronation of Reason, where it's got a fellow trying to run his lawnmower, and it says here, Dundon, Florida fined me $30,000 for overgrown grass. When I was unable to pay the fines, the city voted to foreclose on my home. I'm fighting back to save my house. So,
good.
Perfect example of what you described.
In many cases, it is not in many cases, the lens to think about these, to see these things, is the lens of abuse, of excessiveness, as opposed to a core question of right and wrong.
Perfect. Well, I see you have a question here, Charles. I see your hands up there.
Thanks, Jeff, and great presentation, Lee. Another abusive area is licensing, and you guys have taken the lead on that. Are you involved with any high-profile efforts to repeal licensing or modify it in some way?
Charles, thank you. Occupational licensing has now become the hottest issue in labor markets. State legislators across the country see that the number of Americans who earn the minimum wage is about 1%. The number of Americans who are members of unions is about 10%. But those that the percentage that the government burdens with an occupational license is about 20%. It is the largest institution in labor markets, and the labor market in the United States is the largest market of them all. And so with friends like Laura Epke at the Platt Institute and Erica Janicki at AFP and Heather Curry at Goldwater and other friends, IJ is involved in work trying to repeal individual licenses. We'll always be working on a bill to free hair braiders. That's near and dear to our hearts. But free other do repealer bills, and there's a big one in Florida, but also do sunrise and sunset reviews. So I think there'll be something in Virginia, and there will be other states in which we're engaged in trying to get the legislature and the or various branches of government to scrutinize interest in new licenses by doing a sunrise review, and get them to do sunset reviews, the type that Nebraska and Ohio sunset review processes have enacted. So I see Florida legislation in Florida, legislation in Arizona, perhaps something in Virginia, as well as some other states as well.
Fantastic. David, I see you've got your hand up.
Jeff, Lee, I have two questions. I'm David Demarest with Roads to Freedom Foundation in Omaha. The first question revolves around, it's pretty apparent to me that the abuse of forfeiture is aimed at revenue. And that problem won't be solved until forfeiture is restricted to offsetting fines and costs and that type of thing directly, as opposed to going into education accounts, etc. And my second question is, and perhaps you and Laura could talk about this, how is the Nebraska system addressing that particular concern?
I'll invite Laura to speak about the specifics if she knows how Nebraska, what has occurred in Nebraska since its enactment of criminal forfeiture. But let me talk about the idea of exactly how much money can be seized and how much it be forfeited, and sort of engage you a little bit, David. I think the image the question becomes how big is the fruit of the crime? So is the fruit of the crime $2,000 or $3,000? Is the sale in a state that hasn't decriminalized marijuana or other drugs? Is the sale of those illegal substances, or the profit of those illegal substances, of $2,000 or $3,000? And I think what forfeiture is, in the context of enforcing drug laws, is designed to do is to take away that fruit and to create a disincentive for engagement in those activities. How does that observation fit within your narrowing of the definition of how much money the government should be able to forfeit? David?
So your question is, how does that fit with the idea of offsetting large amounts of assets that have been seized that are clearly connected with the alleged crime?
Right.
And obviously that's a difficult choice. But nevertheless, we have to dig underneath that. Clearly, as I stated, the abuse is aimed at revenue. You can use asset forfeiture for rehabilitation, very unlikely. You can use it for punitive reasons, which are addressed in the size of the assets received. But when you get down to brass tacks, the real problem is the use of forfeiture for revenue.
Oh, David, you're absolutely right about that, and that does create the incentive. And one of the in Tennessee, there was a terrific investigative report about the side of the highway which Tennessee law enforcement was patrolling, and what the reporter successfully showed is that the west side of Interstate 40 there was more interest among those members of law enforcement from Tennessee because cash tended to travel west. By contrast, there was less interest on the east side of the highway because drugs tended to travel east in this small area of Tennessee. So we definitely see it. And in fact, IJ has published a report which shows that forfeiture has not reduced crime, has not reduced drug consumption, and is most engaged in by municipalities that are suffering economic downturns. So I agree completely with this, that this is the real force, and this is the most difficult thing to change at state legislatures. Laura, do you have any insights that you'd like to add about what has happened in Nebraska since?
I don't know that I can give you any hard and fast numbers in terms of money that's come in or stopped coming in or anything. I do know that that they're having to work a little bit harder to get the money and actually have to. One of the things that we noted was that there was sort of this. There was one case that the ACLU handled for sort of an itinerant missionary who was collecting money at a lot of different churches. And he had something like $30,000 in the trunk of his car, got pulled over for a minor traffic violation. They found it, they found the money, and just assumed that it was illicit gains. And so, one of the things that I think is positive about this is that we have to, it requires law enforcement, and it requires the prosecutors to actually prosecute and find out whether or not there's something something actually going on. They let this guy go on his way after they took his cash, basically. So I think stopping that has been a real boon for civil liberties. What I will tell you is, and I think David is absolutely right, that the real inspiration for a lot of this is revenue. I have a very vivid memory sitting on the floor of the legislature the day that we passed this bill, getting a phone call from the Lancaster County Sheriff. My district represented a little piece of Lancaster County, which is Lincoln, and he says, "We need this bill." He says, "That's how we buy our new uniforms and pay for our canine food." And I said, "Well, maybe you ought to just budget for that." And I hung up. I don't see that as a legitimate revenue stream. If it's, again, I think what you get to early on, Lee, is that if it's ill-gotten gains, if it's the fruits of illicit labor, then you can make the case that that you shouldn't get to keep it. But by the same token, when you just have the money and the state decides you shouldn't be able to carry that much money around, that puts all of us at risk if you go on vacation with big wads of cash or whatever.
Well said.
Yeah, and it just goes to show, look at their attitude. It's like they're entitled to those funds. They don't have any, ethics about whether that was a good thing the way they got control of those funds or not. It's just part of their budget. And like you said, once you get on that gravy train, it's kind of hard to break that habit. And they're always short of money because they're always trying to do more than they should be anyway. So there you go. We have some other questions here today. That was pretty enlightening, I assure you. Well, I think that we've got most of everybody addressed. Any kind of closing comments or things that we can sort of do as individuals out there in the real world to help what you guys are up to or in our own area?
Well, Jeff, thank you, and thank your organization for this forum. There is a lot of interest in this area, and the key is the combination of people on the ground under the dome at state capitals. They know state legislators, they know the processes and the deadlines and the interests of state legislatures. The Institute for Justice and other organizations exist to support that type of knowledge, that type of leadership, that type of involvement. And so at IJ, I stand ready, my colleagues stand ready to support organizations that are interested in getting the data through a reporting bill, and then working toward ending civil forfeiture and replacing it with criminal forfeiture. We have the resources and the commitment and the perseverance to do this, and we look forward to working with great organizations like Platt, like AFP, like the Buckeye Institute, like the ACLU, and others to get reforms done. So I invite you to call and welcome the opportunity to work with you.
Fantastic. And again, thanks so much for today. We will certainly stay in touch and continue to follow up, and we'll certainly promote this far and wide, our talk today. So thanks, Lee.
Jeff, thank you. And Charles, thank you.